You're watching Search and Seizure with Bruce Allen Barnard. Brought to you by Leah One, providing legal training you can trust.
In this case, we're going to review the decision from the United States Court of Appeals from the 8th Circuit in the case United States versus Martin Campbell. This decision is dated November 8th of 2021. So let's start by taking a look at the facts in this case. It comes to us from Marion, Iowa. And in May of 2018, at 22:27 or 10:27 p.m., Officer Nicole Hotz was patrolling the Marion High School parking lot there in Marion, Iowa. She was asking people to leave the parking lot at the school because there had been suspicious activity that had been occurring there overnight in recent evenings, recent nights. At that time, Officer Hotz noticed a vehicle pull into this parking lot at the high school, and she pulled up near the vehicle and parked 2 spots away from it so that she could walk up and ask the occupants to leave. When she pulled up, Officer Hotz noticed that the defendant in this case, one of the defendants, Kristen Campbell-Martin, was sitting in the driver's seat and seemed to be hiding her face with her hands. And Officer Hotz at this point shined a spotlight on the driver's side window to get the woman's attention and then walked up to the window. The woman rolled down the window, and at that point in time, Officer Hotz noticed that she was very nervous and fidgety. She also noticed that her speech was quick and her pupils were constricted. And Officer Hotz thought this was unusual especially for the pupils to be constricted because it was dark. I mean, it's almost 11 o'clock in the evening. Officer Hotz also noticed that the woman kept pulling her knees to her chest and breathing really heavy. And based on her experience and these observations, at this point, Officer Hotz thought that the woman might be under the influence of drugs. She also thought it was strange that the 2 male passengers, one in the front seat and one in the back seat, were very quiet, didn't say anything, and didn't even look towards her direction. At that point, Officer Hotz asked for everyone's identification. The woman in the driver's seat and the man in the front passenger seat stated that their names were Shannon McKelvey and Fabian Estrada, but they denied having identification. So Officer Hotz then asked at that point, "What's going on? Run me through. Something's going on here right now." And in response to this, the woman said that the 2 passengers had picked her up because her boyfriend was beating the crap out of her. This caused Officer Hotz to ask her if she was okay. When asked about their Social Security numbers, neither person in the front seat stated that they knew what their last 4 digits of their Social Security number was, which Officer Hotz also thought was strange. At this point, Officer Hotz ran Estrada's name and discovered that it was a false name and that his real name was Adam Leva. So she arrested him for providing false identification information under the Iowa statute. Sergeant Richard Holland arrived to assist Officer Hotz at this point and asked the driver if a purse in the back seat belonged to her. At this point, she said that it did not, and she refused to give him permission to search it. Because the man in the back seat said he was the one who had been lent the car, and therefore the one who was lawfully in possession of it, Officer Hotz asked him to look for identification in the purse. When he found McKelvey's identification, stating that her real name was Kristen Campbell-Martin, the officers arrested her for providing false identification information as well. So now she's been arrested as well as Leva. Sergeant Holland decided to impound the car, asked the man in the back seat to exit the vehicle, and after the man got out of the car, Officer Holland started to search the vehicle and found a backpack on the floor of the front seat passenger area. Inside of the backpack, he found nearly 2 pounds of ice methamphetamine. He also found $2,850 in cash, a small scoop, small baggies, and paperwork addressed to Leva and Campbell-Martin, which was important evidence for proving constructive possession of the methamphetamine. In the center console, he found Leva's identification, and after he finished searching, the car was impounded. A federal grand jury indicted the pair, Campbell-Martin and Leva, on 1 count of possession with intent to distribute a controlled substance near a protected location, that being the high school, and aiding and abetting with the possession with intent to distribute. Campbell-Martin and Leva moved to suppress the methamphetamine that was found in the car for two separate reasons. First, they argued that the initial encounter was an unconstitutional seizure because Officer Hotz did not have probable cause to arrest or reasonable suspicion for an investigative detention. If they were unlawfully seized from the beginning, then the subsequent arrest and the search was tainted, and the evidence that was subsequently found should be suppressed as fruit of the poisonous tree. Second, they argued that even if the initial encounter and arrest was lawful, the subsequent warrantless search of the vehicle and its contents was an unconstitutional search, and the evidence should be suppressed as an unlawful search incident to arrest or unlawful inventory. So they made two distinct arguments for the suppression of the evidence. The trial court denied the motion and concluded that the defendants were not seized when Officer Hotz first approached them, that after she approached them, she had probable cause to command them to exit the car and arrest them, and the search of the car was a valid inventory search and search incident to arrest, and the defendants at that point conditionally pled guilty to possession with intent to distribute a controlled substance. So we have two issues on appeal here to the Eighth Circuit. First, whether the initial encounter was an unlawful seizure, and second, whether the search of the vehicle and the subsequent search of the backpack were unlawful searches. Okay, before I discuss how the Eighth Circuit ruled in this case, let me take a few minutes here to review the law that's applicable to the issues that were presented, and got a couple of really interesting concepts, and it's always a good idea to have a little bit of a refresher. Use these cases in order to learn and review concepts. It might have been a while since we've dealt with them. Let me first start with the seizure of a person and what constitutes a seizure of a person. And a Fourth Amendment seizure of a person occurs when an officer, either physically by means of physical force or through command, show of authority, has in some way restrained the liberty of a person. The crucial test is whether, taking into account all of the circumstances surrounding the encounter, one of those totality of the circumstances, the police conduct would have communicated to a reasonable person that he was not at liberty to ignore the police presence and go about his business. In other words, would a reasonable person believe that he or she was free to in the encounter and just simply walk away? So the test is from the perspective of this theoretically objective, reasonable person. It's not a subjective test. It's considered an objective test, at least legal objectivity. And therefore, it doesn't matter what the person subjectively felt. It doesn't matter whether or not they thought that they were free to leave. It's immaterial to the decision, because that's their subjective take on it isn't what determines whether or not they were seized. It's this objective test. So in order to determine whether an encounter is a seizure under this reasonable person standard, a court looks at the totality of all of the relevant circumstances, and specific circumstances that suggest a seizure has occurred. They give examples in many of the cases, and they include the threatening presence of several officers. In other words, you have several officers around one person, the display of a weapon by an officer, the physical touching of the person, the use of language or the tone of voice indicating that compliance with the officer's request is compulsory. Those are some of the circumstances. It's important to note that requesting identification or simply asking questions of a person does not in and of itself constitute a seizure, as long as the police do not convey a message that compliance with their request is required. And so if it doesn't rise to that level, just requesting identification or asking someone questions, it can still be a consensual encounter. That does not turn a consensual encounter into a seizure. And the courts have said in previous decisions, all the way up to the Supreme Court, and recognizing the three types of encounters that we have with a person, right? A consensual encounter, a detention, or an arrest. And so when do we go from this consensual encounter into a situation where we're seized, either a detention or arrest? And those are the factors that they look at. So there you have a little refresher of the seizure of a person. A blue key case for that, what we call here at LEA 1 a blue key case, a Supreme Court decision that has a key impact on law enforcement. The blue key case for that concept is Florida versus Bostic, which was a 1991 decision. So let's look at the next legal concept here that we have to be aware of in order to understand how the Eighth Circuit decided this case. And let's talk about Terry stops and the notion of reasonable suspicion. Now, the Fourth Amendment requires that officers have to have a warrant to see someone, either a warrant or what I refer to commonly as a JRE, when that's just an acronym for a judicially recognized exception to the warrant requirement. So we have to either have a warrant or a judicially recognized exception. And that's not just with seizures. That's also with searches. Any action, any government action that constitutes a search or a seizure under the Fourth Amendment has to be reasonable. And reasonableness requires either a warrant or a judicially recognized exception. Now, there is an exception for a temporary detention, an investigative detention. It's also called a Terry stop. It's named after the case that created the exception. And under the Terry stop exception, officers can conduct a brief investigatory stop of an individual if they have a reasonable, articulable suspicion of criminal activity. Is that person involved in criminal activity? Reasonable suspicion is significantly less of standard than probable cause. On those levels of suspicion, reasonable suspicion falls underneath probable cause. A law enforcement officer has reasonable suspicion to conduct an investigatory stop when the officer is aware of particularized objective facts which, taken together with rational inferences from those facts, reasonably warrant suspicion that a crime is being committed. And again, to determine whether an officer has reasonable suspicion, a court considers the totality of the circumstances. The last legal concept, that's not quite as simple, not as easy to grasp as the first two, is the notion of a search of a vehicle incident to arrest. And we've got the Arizona versus Gant decision. In this case is in this type of scenario is very important. The Gant decision is the leading case, a blue key case for this. And there are a number of cases for the search incident to arrest, but Gant specifically dealt with the search of a vehicle incident to arrest. And it's important to point out here and to know that police may search a vehicle incident to a recent occupant's arrest only if the arrestee is within reaching distance of the passenger compartment at the time of the search, or it's reasonable to believe the vehicle contains evidence of the offense of arrest. Now, that's a quote from the Gant decision. And so the fundamental principle is, Gant says that you cannot search a vehicle incident to arrest unless you meet one of these two exceptions. And again, there were two of them that were separated with an or there. So let me go back and make sure you understand. The first Gant exception is you can search a vehicle incident to arrest if the arrestee, the person being arrested, is within reaching distance of the passenger compartment at the time of the search. So in other words, under the first Gant exception, in order for you to search a vehicle incident to arrest, you'd have to leave the person that's been arrested in the car while you're searching the car incident to arrest. And not a very smart idea, right? And you've already got this person under arrest. And so anything that you find in the car would be, icing on the cake, so to speak. The second Gant exception is a little bit more tricky, a little bit more confusing, but very important to understand. And Justice Scalia kind of put that in the decision there in Arizona versus Gant. And this is the second. It's called the second Gant exception, and that is it's reasonable for the officer to believe that the vehicle contains evidence of the offense of arrest. So in other words, the officer has this reasonable belief that evidence of the crime for which the person has been arrested will be found in the vehicle. Now, it gets a little tricky here, and let me explain why. In a lot of situations, in many Supreme Court and lower court decisions, the court has used the term reasonable belief as part of the definition of probable cause. And so, in looking at that, from most of the time when you see the term reasonable belief used by the court, they're talking about using in a definition, defining what constitutes probable cause, but not here, not in the Gant case. It's kind of unfortunate they use the term reasonable belief instead of reason to suspect instead of believe, and then made it straight up reasonable suspicion. But that's the way it's been interpreted by the lower courts. The second Gant exception, a reasonable belief that the vehicle contains evidence of the offense of arrest. They've taken that reasonable belief to mean reasonable suspicion and not probable cause. The Supreme Court hasn't ruled on that, but the way the lower courts have interpreted it is as reasonable suspicion. And let me tell you why. And it makes perfect sense. If you're familiar with the automobile exception, if you have probable cause that there's evidence in an automobile, then you can search the automobile under the automobile exception. So if the second Gant exception, if the term reasonable belief was read to mean probable cause, then the second Gant exception would not give you anything that you didn't already have under the automobile exception. It'd be meaningless. But the lower courts have said, no, that's not the standard. It's not probable cause. The reasonable belief in the Gant decision means reasonable suspicion. And so the lower courts have held this akin to reasonable suspicion. Like I said, otherwise, it wouldn't make any sense because the automobile exception would already apply to the search. This isn't the only place the Supreme Court has used the term reasonable belief, and where the lower courts have said that's not probable cause, it's reasonable suspicion. I'll give you another quick little example. There's four situations where they've done that, but another quick little example is in when you're doing a protective sweep. The notion of reasonable belief that there's someone else there that presents a danger to you in order to do an extended protective buoy sweep, and the courts have said no. The lower courts have said that's reasonable suspicion. That's not probable cause. So there's a number of places where reasonable belief has been interpreted to be reasonable suspicion and not probable cause, and so that leaves us with this second Gant exception that basically says if the officer has a reasonable suspicion that evidence of the crime for which the person has been arrested will be found in the passenger compartment of the vehicle, then they can search the passenger compartment incident to arrest. And getting back to search incident to arrest of the passenger compartment, that also includes containers in the passenger compartment, like the backpack that was found in this case. Okay, now that we've had a good little review and refresher of the law that's going to govern this decision, let's take a look at what the Eighth Circuit actually did in this case. The Eighth Circuit held that considering all the relevant circumstances, the officer's initial encounter with Campbell-Martin and Leyva was not a Fourth Amendment seizure because it was a consensual encounter. Officer Holtz's conduct would not have communicated to a reasonable person that he could not leave. And Officer Holtz was alone. She did not display a weapon. She didn't touch the defendants, and she did not use any forceful language. She parked beside the car rather than in front of it or behind it, so the driver would have been able to drive away. She also did not ask the occupants to get out of the car until she knew they had provided false names. Also, requesting identification or asking questions did not make this a seizure as long as the police didn't convey the message that compliance with their request was required. And when she asked for identification, her tone was conversational. She framed her request as a question, and she said, please. And when she said, what's going on? Run me through. Something's going on right now. She did not use an authoritative tone of voice, and she asked if Campbell-Martin was okay when Campbell-Martin said that her boyfriend had beat her up. The court held that, furthermore, even if it became non-consensual, the officer had reasonable suspicion to question them and ask for identification. Even before Officer Hotz asked to see the defendant's identification, she observed them driving into a school parking lot at around 10:30 at night. Campbell-Martin at that point appeared to hide her face with her hands, and she didn't look at Officer Hotz after Officer Hotz shined her spotlight on the driver's window. And after approaching the car, Officer Hotz had reasonable suspicion to believe that Campbell-Martin was under the influence of drugs because she was nervous and fidgety, and her speech was quick, and her pupils were constricted, and she kept pulling her knees to her chest and breathing really heavy. Officer Hotz also observed that the two passengers were very quiet and did not look at her. And based on her training and experience in dealing with individuals under the influence, she reasonably believed that Campbell-Martin might be under the influence in this case. Officer Hotz had reasonable suspicion, based on articulable facts, to extend the encounter to investigate whether Campbell-Martin was driving under the influence. So in other words, at that point, she had the reasonable suspicion necessary to turn the consensual encounter into an investigative detention, which is a seizure under the Fourth Amendment. The court also concluded that the search of the car and the backpack without a warrant was lawful under the Second Gant Exception. The court held that it was reasonable to believe that the vehicle contained evidence of the offense of providing false identification information. Right? Although the officers already knew that both Campbell-Martin and Leyva had provided false identification, they didn't have Leyva's actual identification, which would help prove the false identification until after they'd searched the vehicle and found it in that center console. It was reasonable to think that his identification would be in the car because he had not given the officers any identification even after he was arrested. And therefore, the court affirmed the district court's denial of the motions to suppress. So let's take a few moments to summarize the takeaways and what we've learned from this case, the takeaway for law enforcement here. First of all, keep the encounter consensual until you develop reasonable suspicion. Make it consensual. Be careful that you don't make this detention from the beginning, right, with this notion of what constitutes a seizure. Would a reasonable person believe they were free to end the encounter, right? Remember a couple of years ago, I did a webinar and a podcast on a case called United States versus Gaines, and I was reminded of this case. It popped into my head when I thought of this, and I'm like, well, this is similar to the Gaines decision with a totally different outcome. And what was the difference? Remember the Gaines decision out of the 10th Circuit back in March of 2019. United States versus Gaines. Officers there went into the parking lot. They had a anonymous tip that someone in the parking lot was dealing drugs. That's all they had. So they didn't have a reasonable suspicion or probable cause. They just had a tip, an anonymous tip. So they went into the parking lot with their lights on, got behind the car, pulled in behind the car, ordered Gaines out of the vehicle, and eventually drugs were found, but the drugs were suppressed, and the court ruled, the 10th Circuit ruled, that this was not a consensual encounter. And if you contrast that, compare the facts of that case with the facts in this case, you can see the difference. And she didn't have the lights on. Officer Hotz didn't. When she pulled up, she parked a couple spots away. She didn't block block them in, so they could still in the vehicle. They could have still kept going at that point in time. No commands were given, and so it didn't rise to the level. They kept it consensual, kept that encounter consensual until the point that they had developed the reasonable suspicion, and that's key. Use the consensual encounter to develop the reasonable suspicion, and be able to articulate the reasonable suspicion before you turn it in to an investigative detention. And when I was at FLETC, we would hound on that over and over, right? And not conclusions, facts. Articulate the facts Don't say that you had a suspicion. Articulate the facts that would demonstrate this objectively reasonable suspicion. Be able to articulate those facts before you turn it into an investigative detention. And lastly, understand that second Gant exception, right? Do you have a reasonable suspicion that evidence of the crime for which the person's been arrested will be found in the vehicle? Now, we don't see the second Gant exception used a lot. I'll tell you straight up, and this one of the reasons I picked this case to make this case a case of the week here. It's important to know the second Gant exception because we don't see it a lot. In many situations, when we arrest someone in a vehicle, we have probable cause that there's evidence in the vehicle. And in that situation, we're using the automobile exception to get into the vehicle to do the search, and not the Gant exception incident to arrest. And so many times when we arrest people out of a vehicle, as a result of the probable cause that leads to the arrest, it also gives us probable cause that there's contraband or evidence in the vehicle. But sometimes we don't have that, and this is a really good example of it, a good takeaway, good use of the second Gant exception, and a good example of it that led to the seizure of nearly 2 pounds of ice methamphetamine. So a good result in that case. Hats off to the officers. Did it right, lined up those Fourth Amendment dominoes right, and did it right, and the evidence was not excluded under the exclusionary rule as a result. Know the law, and use the law. This episode of Search and Seizure was brought to you by the search and seizure experts at Lea 1. Folks, nobody does it better. Nobody teaches search and seizure law better than the folks at Lea 1. Nobody knows it better, and no one teaches it better. Lea 1 is the only legal training provider with all of the following credentials. First of all Lea 1 instructors are either FLETC certified senior legal instructors or State Police Academy legal instructors with years of experience training tens of thousands of law enforcement officers across the country. Nobody else can say that. But it doesn't stop there. All Lea 1 instructors are former prosecutors with extensive experience defending motions to suppress evidence, which is an incredibly important part about understanding and knowing the law, search and seizure law. Furthermore, all Lea 1 courses are professionally designed by certified curriculum development specialists. All Lea 1 lesson plans are continuously updated and are peer-reviewed annually for accuracy and sufficiency. Professional legal training, that's the Lea 1 difference. This presentation is provided for purely academic purposes. I'm fond of saying I'm a lawyer, but I'm not your lawyer. And what I mean by that is that I do not provide formal legal advice through these presentations. No part of this presentation is offered, nor should it be construed as legal advice. If you need formal legal advice regarding any part of this presentation or have legal questions, you should consult with your attorney.